Good evening. This is Rahul Reddy. We are live here from Houston, Texas. Along with me is my business partner, Reddy Neumann. Emily, what do we have today to discuss?
Today we wanted to talk about the H-1B lottery for this year, which is technically fiscal year 2024, even though we're just in 2023. Particularly, is there going to be a second round in the lottery? Are there any possibility of having another selection? We also want to talk about USCIS's tweet where they mentioned that you can change status from H-1B to B-2 if you are laid off from your job, and that then you can change status back to H-1B and they'll prioritize those applications. They also updated that on LinkedIn just today and seem to have added this to their FAQs about situations and options when you're facing a job loss situation. So we'll go into that in a little more detail. We also wanted to cover the steps in the timeline for the PERM labor certification process for people who have not gone through that yet or have not gone through it recently. We'll talk about what that timeline is, why is it taking so long, and what you can expect based on current timelines. And lastly, a common situation that we're having right now is what happens in a situation of a job loss when your I-485 application is pending for employment-based. Can you still get the green card? What are the options for that? So going back to the H-1B lottery, what are your thoughts on that? Do you think that there's going to be a second one?
Emily, in the past 3 years, though, they have conducted the lottery second time 2 times. But they didn't do it last year, though. The main reason why they didn't do last year was that the first 2 years, they were unable to calculate how many people would not be able to file. That means once the lottery is selected, would they get all the applications? Because the previous experience was completely different. We used to file all the applications along with the filing fees. Only when everything is perfect, they used to accept the case, and then they used to give us the lottery information, though. This time, they're just with the $10, they're giving the lottery information in the past 3 years, I'm going to say. And after that, they will request the people to file the H-1B, but if they don't file, then they have conducted the second lottery. For the first time, they conducted in this fashion, where $10 thing came in. And also second time, they conducted also multiple times the lottery. Now, when it comes to the third time, though, they realize that, oops, some of the people are not filing the H-1B, even though they did pay the $10, even though they did got selected in the lottery. So in the third time, they did select a lot more than what is needed for them to get the 65,000 H-1Bs. Of course, 65,000 plus 20,000 master's degree, 85,000 H-1Bs. So they selected a lot more people last year. That's the reason we haven't seen any second lottery last time. Now, however, this year also, they did select a lot more than what they are supposed to. That means 85,000. They did a lot more than 85,000. But I do have a feeling, because of the number of applications that were received seems to be about 500,000 applications, there may be a lot of fraudulent applications where people might have filed with multiple companies at the same time, which is fraud, of course. So they at least may not be able to file if they have been selected multiple different places. They may not be able to file. And I just want to tell the audiences that these people who fraudulently file the H-1Bs will eventually get caught up and they will eventually be terminated from this country. That's a different issue, though. But initially, if they are selected in the lottery with multiple companies, they may not be able to file it. I think so. There may be a lottery, second lottery this time, Emily. What do you feel?
Yeah, I mean, the difficult thing is, number one, we still don't know how many registrations there actually were total. And number two, we don't know how many they selected from that. So last year, we do have that information that there were 483,000 registered, and of that, 127,000 were selected to get to 85,000 H-1B filings and approvals. This year, we don't know. With such a low selection rate, it feels for sure that there's more than 500,000 that were registered. Did they select a high number or even a higher number this year so they can actually get to 85,000? I think we'll know more when we know exactly how many registrations there were. my guess is there could be a second lottery this year.
Okay, so we both agree on this one finally.
Yeah, but it won't happen till after June 30th, because that we have until June 30th to file all these petitions. Then USCIS will figure out how many they actually received. Then they'll conduct a second lottery. They don't announce it. All of a sudden, we just start getting emails saying something has happened in your My USCIS account. We have to log in, figure out which ones were selected the second time around, and then there'll be a new filing window.
Emily, what do you think of people who are working with a company? Let's say I'm working with Apple, or let's say I'm working with Deloitte, and they filed in the H-1B lottery. Now I got a better offer. Should I leave? Should I stay because it's going to be second lottery? What should people make decisions on it on the lottery system, though?
You mean if they didn't get selected in this round?
And they're waiting for
that's a tough one, because that definitely happened. Obviously not last year, but in the prior years, people made decisions to leave the country or leave their job, and then 3 months later found out, oh wait, I did get selected, and now that employer is not going to proceed because they're no longer with them. So now might be a risky time to make a job switch. Of course, if you don't, if you're being terminated, you don't have a choice there. But if you have the employment authorization, you may want to consider staying until after June 30th to find out if there's a chance that you got selected in a second lottery.
Yeah, it's a very tough decision for people. So you need to make it very judiciously because there is a chance for second lottery. Emily, on the USCIS tweet that said that recently, which is a good news, because when we were applying people who are on H-1B, when they lose their jobs, we used to apply for B-2 visa. And then later on, when we were switching from B-2 to H-1B, the USCIS used to tell, wait a minute, your B-2 is not approved, so we are not going to approve the H-1B with the change of status because your B-2 was never approved. So then they had to go back to India, and most of these people have to get a stamping in India, and the stamping was a very tough deal, at least in those days. It's getting a little bit better right now. But what is this tweet about, and how is it more advantageous to the people who are in situation who are losing jobs, who may be wanting to consider to apply for B-2, to linger around a little bit more, maybe to dispose of their properties, or maybe try to see it. Maybe they'll get another chance a little bit later on with a different company. Can you explain how this tweet and the later on explanation by USCIS is helping the individuals?
Yeah, it definitely basically provides people with up to 6 months more time to be able to find a new job, to be able to take advantage of the grace period and get back to H-1B status. So I think we all know that in the event an H-1B holder is terminated, the 60-day grace period begins, and you have 60 days to find a new employer and file a transfer, and you're considered to be maintaining H-1B status that whole time, even though you weren't working for that 60-day grace period. Problem comes in, 60 days goes by very fast. The pipeline or processing of job interviews and submitting the applications and multiple rounds of interviews and all of that takes time, a lot of times more than 2 months. Even if you get the job offer in time, it takes more than 2 weeks to file the H-1B. And with some of those bigger companies, it takes more than a month to get it filed. So you really have a very short window. So as a backup plan, one option is before your 60-day grace period ends to file a change of status from H-1B to B-2 visitor visa. You can request a 6-month stay on B-2. So that allows you an extra 6 months to dispose of property, to continue searching for a job, to see if you can get back to H-1B. Now, the good news is, because the B-2 processing time is well more than 6 months, you're not going to get an answer on that anytime in the near future. But let's say you filed that change of status to B-2 at the 60-day mark, and now at the 90-day mark, you got the job offer. The new employer can file a change of status from B-2, even though you're not in B-2 yet, back to H-1B. And if that's filed in premium processing and references the pending B-2 application, USCIS has confirmed that they will prioritize the B-2 application, and they will approve your change of status to B-2 and your change of status back to H-1 simultaneously. So you don't have to worry about exiting the US, applying for a new visa stamp, and getting back. You can do all of that within the US. So that's a big help for people that are already suffering because they're in a job loss or in that time crunch. And then now you finally got the job offer. You have no way to get back to H-1B. Now you have a way to do that without having to leave the country.
Emily, with regards to the PERM labor certification, we used to get the PERM approvals, and there are times where I've got even PERM approvals in 1 week, though.
Those were the good old days.
Yes. Now, why is the time process for some of the companies taking like almost 2 years to get the labor certification approval? And what is there any way to expedite this? And what do people need to do? Because a lot of people are ignoring, oh, my friend got his labor certification from start to finish in 3 months. I'm going to wait until 5 years and 8 months to apply for my labor certification. Then I can extend my H-1B for 6 years. First, I want you to explain what is going on in the labor certification and what people need to do for those people who are waiting to apply for the green card application.
Yeah, so there are multiple steps throughout this process. There are specific deadlines and timeframes for each step. So when you start the process, understand first that it's going to take some time, especially for larger employers that are working with larger law firms. It takes them time to develop the job description that they're going to use throughout this process. Even though it might be your current job description, they have to boil it down into one short paragraph. They have to determine what the minimum education required for your job, what field of studies they'll accept for that job, how many years of experience are needed, is there an alternate requirement that they'll accept, are there any special skills or certifications needed or a license needed for that job. All of that has to be nailed down before anything can happen. And there's a lot of back and forth that happens between the attorney and the employer or the manager of the employee to get that all decided. So that in itself can take 6 months at some firms and at some employers. It shouldn't take that long, but sometimes it does. Once all of that's finalized, now we can move forward to actually submitting the prevailing wage. And that is what kicks everything off. The problem is the prevailing wages are now taking 7, 8, 9 months to process. And that is a very long time. It's never taken that long before. And yes, there are ways that you can begin the recruitment phase while you're waiting on the prevailing wage. But because the processing times keep getting longer and longer, if an employer starts the recruitment too soon, their recruitment might expire before you even get the prevailing wage in. Then they have to start it all over again. It wastes a lot of money because those advertisements are very expensive in the newspaper. So because of that, some employers prefer to wait until the prevailing wage comes in and then they'll start their recruitment. So now we're already at the 7, 8, 9 month mark. For starting recruitment, it takes a minimum of 2 months to get through that process. Maximum is 6 months. But we have to post a job order for 30 days and we have to wait for 30 days. There has to be a 30-day cooling off period. Then there's multiple other things that happen during that time period, but that's basically the fastest you can possibly do recruitment is about 2 months. It can take longer depending on how often and how close together all of the ads are done. But also remember that this is recruitment. This is meant to try to find a U.S. worker for the job because they can't proceed to sponsor a foreign worker if there's a U.S. worker available. So employers may be getting resumes from applicants applying for this job. They have to go through those, decide whether someone might be minimally qualified or not. They might have to interview that person to determine whether they might be qualified or whether they're even a U.S. worker. All of that takes time. And then they have to put together a recruitment report of all the applicants they've received, who, whether anyone was qualified, whether anyone was offered the job, if they weren't qualified, why. It's a very detailed process. And then they can finally file the labor certification. So all of that can take a good year just to get to the point of filing, if not longer. And then once you're filing, they're taking about 9 months to process right now. So ultimately, plan on at least 18 months to get from start to finish. Really, you'd be better off to plan on 2 years. So the best thing to do, if you're in H-1B already, right after your first extension gets filed, make sure you're starting your PERM process. Even better, start while you're in your first 3 years. There's no requirement for you to wait. There's no waiting period at all. It's just some companies may have a policy on that. But if the longer you wait, the bigger the risk that you're going to max out of that time. Okay, so one of the other topics we wanted to talk about is what happens if your 485 is pending based on an approved I-140, and now at this point you lose your job. Is there still a way for someone in that situation to receive their green card? What should they do at that point?
Emily, if they lose the job, though, first thing they need to contact a lawyer. If they can find another job immediately, that's good. But there are 2 questions. Is that when you are changing the job, are you changing the job after 180 days or before 180 days? So if somebody loses a job after 180 days and they find another job in a similar occupation, absolutely no risk at all. You are absolutely fine. You don't need to do anything. You're good. Now, the question that comes is that if it's after 180 days and you don't find a job at that point of time, a lot of people are under the assumption that there is a 60-day grace period. No, that 60-day grace period, people are misinterpreting it because that's for H-1B though. There are a lot of options, Emily, people can explore. Self-employment is one thing. Their spouse can employ them. Get an offer from a job from a different company, even though they may or may not be willing to join that company immediately, because it's all about job offer. It's not about whether or not you have been employed with that company. Also, when you lose a job, since the company has not withdrawn the I-140 application, they did not withdraw the offer of employment with the 485 application, we can still make an argument that even though you lost the job, you may still be able to get the green card because the previous company has not withdrawn the I-140 application or the job offer. Of course, they have some inherent risks in it, like the self-employment, spouse employing, and also when we are making the argument that the job offer is still there, even though you're not working for the company, there are some risks involved in it. But we were been able to successfully navigate. As of now, we didn't have any failures when we advise the clients that you can still do these options. We haven't seen any denials of the 485 yet, Emily. But of course, there's always a chance that there is a risk involved. I would advise people who lose their jobs, though, if you find another job after 180 days, you're good. But otherwise, I would request that you contact a lawyer to walk through the path so that you take care of all the steps that are needed, though. Is it needed for the people to file a 485J immediately after they lose the job? It's not needed for them to apply for the 485J immediately. Anything else, Emily, that you want to discuss on this?
Yeah, so basically, yes, if there's a job loss situation, there are some potential risks there, but it doesn't mean you should throw up your hands and walk away from the green card. I mean, you've basically spent all this time in the U.S., gone through all these processes, and are finally, the light's at the end of the tunnel. You're so close to receiving it. There are ways that you can continue to fight for it and be successful, even if you're in a job loss situation. But definitely talk to a lawyer about what those options are and the timing of them and what needs to happen when.
There are a couple of questions on the 485J. I want to address those questions, Emily. Some things going on between some arguments, which are very healthy arguments between Indradeep Singh and Arun. So they're arguing, they're discussing, very healthy discussion. It seems that one of the company for Indrajit Singh, they don't want to file the 485J supplement they want to employ them, but they don't want to apply the 485J supplement. Are there any significant risks involved in it is the question Indra Singh is asking. The main question would be that a lot of companies are not filing the 485J supplement when you join the company, though. They are willing to do it only if there is an RFE or if there is an interview. In your case, I don't know if they are not going to do ever, or is it only they're not going to do right now? If they're not going to do right now, they're going to do it at a later stage. I'm absolutely fine. You'll be fine to go and join that company. The question that comes is that if they are not going to do the 485J supplement, then you will be at a risk, because when there is an interview or when there is an RFE, you need to find a different employer to give you the 485J supplement. That's the risk that you'll be facing. And I see Arun, who was also responding to it, saying that he thought obviously that the employer is going to file the 485J supplement. Yeah, sometimes you might want to check with them on that, though. A lot of the companies are right now are telling that they're going to do it when there is an RFE. Is it required, Emily, that they have to file a 485J supplement immediately before joining, or can they file later on, Emily?
Yeah, there is no requirement on that. When that form first came out, we were generally recommending people to file it when they join so that you can avoid an RFE asking for it later. But since that time, it seems like they send an RFE anyways, and you're not really getting much benefit out of proactively providing it. So we are generally waiting until there's a request for evidence or an interview for submitting that supplement J. So I don't see any problem if the employer doesn't want to submit it right away.
Vikram has a question on the same topic. After H-1B grace period, how long can I be unemployed on the EAD and AP? Vikram, that's a very wrong question, though. First thing is that there is no 60-day grace period for the adjustment of status. You're misinterpreting it. I would definitely recommend that you contact a lawyer immediately, though. As I was pointing out before, the 60-day period is not there, but there are very many exceptions available for the adjustment of status. A lot of people are on the assumption that, oh, we have a grace period. No, you don't. You don't have the grace period for the adjustment of status. Let's dive into the questions, Emily.
All right. Yeah. Dick Jyoti says, I'm on H-1B and have an approved I-140 and was recently laid off. I also have the F4 sibling petition in 2020, the I-130 there. Can I apply for a change of status to B1 or B2, and do I have to withdraw the family-based F4 petition? So interestingly, USCIS has actually added a Q&A to their section on their website about these layoff situations. And they mentioned, can I file a change of status to B1 or B2 if I have a pending or approved I-140? And USCIS says, yes, you can. It should have no impact on your change of status request as long as you're intending to depart at the end of the B2 stay that you're requesting, and you have a residence abroad that you continue to maintain that you don't intend to abandon. So it looks like they're overlooking the fact that people have an approved I-140, which should be the same situation for those with an I-130, particularly when it's the F4 category and your date is not going to be current for the next decade. I don't think they would put that into consideration. So seems to be that should be allowed as long as you have the intention to depart and you have the residence abroad that you don't intend to abandon. That answer would be different if someone was applying for a B1, B2 at a consulate, because there they are definitely looking at all of those factors to determine whether you have immigrant intent, which is not allowed on a B1, B2. But USCIS is looking at it more from a standpoint of how can we help people in these layoff situations. And they seem to be saying, yes, it's okay to file a B1, B2 in that situation.
A question from VT. He has a DUI in 2010 and he got an RFE for the 485 to get the certified document. What kind of documents are needed to answer the RFE? First is the certified document of the court disposition. Disposition means that the case has been dismissed. I mean, the case will be dismissed. Even if you have paid a penalty, even if you have served some sentence, also the case will be dismissed. So that particular thing is definitely important. The arrest document, normally people may not be able to get the certified document, but if you can get the certified documents, what is the arrest document? This is the document where the police will say, will write in his notes saying that, oh, I saw this guy turning right without giving a right indicator. So I stopped him. I went and I was asking for the driving license. I smelled alcohol, and then he's going to write all the description. So those are the things that are needed absolutely. Sometimes this police report, you may not be able to get the certified, but at least if you can get, I would like you to get it. And also all the interim documents that the court has initiated on you, from the beginning to the end, all the way to the disposition, if you can get the certified documents, those are needed for you to get your 485 cleared. Now, when, a lot of people, what happens, Emily, is that when the DUI happens, okay, they complete the DUI, everything is over, then comes 13 years down the line, they don't have documents. They delete all the documents that are so old. So I tell people, Emily, that once the incident happened, get the certified documents. I tell them get 10 pieces of the certified document because they needed to file the 485. And sometimes when they go for the interview, they needed to give it to the USCIS officials. When they file for the citizenship application, they need it. When they go for the first time for stamping in in India to get the H-1B stamping, they need the original documents there too. At least 4 occasions. So minimum of 6 certified documents, set of certified documents is what I recommend. Because when you go there, you might as well get it done, all the things, all the way to the citizenship, okay? Because otherwise, every time you have to make a trip to that particular court and make it, it's going to be costly for you. Spend $200, get 10 certified copies of everything. That's going to be easier for you rather than dealing with the lawyers, dealing with all the people at a later date. And some of those records may not be existing if they become very old.
Yeah, and also a lot of people are able to later get their criminal records expunged, meaning that it gets deleted from your records, and the attorney and the judge will tell you, you don't have to disclose this criminal issue anywhere anymore because it's been expunged. That counts for everything except U.S. immigration. And once it is expunged, those records are deleted forever and you can't get them back. So for that reason, as Raul said, at the time it's happening, get all of the original documents, get the certified court disposition, and keep extra copies of it. Because if you later do have it expunged, you're still going to need to provide those documents. Question on PERM. Mine just got approved, and I have an earlier approved I-140 with a 2010 priority date. What is the best way forward? Well, you have a couple of options, since obviously you can retain that priority date on the new I-140 filing. You can either file concurrently, since assuming your date is current for your category, or you can get the I-140 approved first and then file the 485. We were having a lot of issues with the concurrent filings because they were always going to the Texas Service Center and then they were being delayed. Nowadays, I think the I-140 is going to Texas or Nebraska, but the 485 is being routed to the National Benefit Center. So it really just depends on if you're wanting a faster processing time. You may want to consider filing the I-140 first in premium, and then as soon as that gets approved, file the 485. So it goes straight to the National Benefit Center. Of course, you want to know what the next month's visa bulletin looks like before you make that judgment call, because there's a chance that the dates might retrogress and you won't get your 485 filed in time if you're waiting on that I-140 approval. So you may want to wait a couple of days to decide and then choose whether to file concurrently or to do premium I-140 first and then file the 485.
Vikram has a follow-up question with regards to he's still unable to get the employment. He is considering what can he do for saving the green card application. Well, if you're not going to get employment, can you check if you're married to see if she's going to employ you? Of course, in that profession. That's one thing you may want to check. If not, self-employment is another option too. These are desperate measures. You've been working in this country for a long period of time. I can assure you that other people that he's been working for in this country for more than 10 years. You don't want to give up the green card just like that. So you have to do as much efforts as possible. If every effort fails, go to your wife, check with her if she's willing to employ. If not, well, self-employment. That's also allowed too.
Anjali says, I'm working on H-4 EAD for 2 employers, and my H-1B was picked this year with 1 employer. How can I continue working for both employers after October 1st? So you have a couple of options. You could have your employer that got selected file the H-1B change of status, and then beginning on October 1st, the second employer can then file a concurrent H-1B to allow you to work for both companies. Your other option would be, as you mentioned, you could get the change of status to H-1B approved, let it take effect on October 1st, and then use automatic revalidation to return to the U.S. to your H-4 status by leaving, showing you're going to Mexico or Canada for less than 30 days. You don't need a valid visa stamp to come back to the U.S. You show your expired H-4 stamp, your valid I-797 approval notice from your H-4 that has the I-94 attached on it that's not expired, and you inform the officer that you're coming back into the U.S. to be with your H-1B holder spouse. That gets you back to H-4. You can then use that EAD that you already had and keep working for both companies, but keep the H-1B in your back pocket now that you've been selected in the lottery, so you're not subject to the cap anymore.
A question that is coming from Vivek. Any updates of stampings in United States? Yes, we are expecting the visa stampings in United States by the end of this year. We don't know at this point of time what categories it will be. We are expecting it most probably will be H-1B. H-4 extensions will be covered. We don't know if the change of status from F-1 to H-1 will be covered or H-4 to H-1 will be covered. We yet don't know though. We can only predict that it will be the extension of the H-1B. The reason is that previous to 2004, that's almost like 20 years ago, that's how it used to be. I remember that. I just want to let everybody know that this month we are celebrating 26th year of existing Reddy Neumann PC. Thanks to everybody in our office, thank all of your audiences to keep us going and keep us, in business. Thank you very much. This will be our 26th year. But yeah, 20 years ago, to the point, that was the system. We don't know if they're going to continue that one the way it used to be, or will they expand to the change of status? Muni has this question. Can a 16-year-old travel alone to USA on advance parole while his parents are in India? Assuming that the parents are going to join very quickly, though. I don't see any problem for the 16-year-old, but I'm assuming that if the 16-year-old is going to come with some other adult, though, doesn't have to be related to the 16-year-old kid. I would rather want to have an affidavit given by the mother and the father that this child is allowed to travel along with John Doe, whoever the cousin or might be, just in case if somebody stops, hey, why are you traveling? This is not your dad or mom. Then he can show the affidavit just in case to clear the kid of any problems.
Amit says, can I travel to India while my H-1B visa extension is under process? So, technically, yes, but probably the better question is, can I come back? How can I come back to the U.S.? So that's where the problem can be. So yes, you can leave while the extension is pending, but to be able to come back, you need to know, is the extension approved, especially if your I-94 from the prior approval has expired. There's no way to come back until you get the extension approved and you go for stamping, and then you can come back into the U.S. That is a little bit risky, because what if your extension gets denied? What if while you're outside the U.S., there's an RFE and the employer decides, I don't feel like responding to this guy's not even here, and they withdraw? Now you have no way to get back. So it's very risky in my mind. So the better choice is, if you've got the valid visa stamp and you have some time, travel first, come back, and then file the extension while you stay in the U.S., or file your extension in premium processing, get it approved, and then travel and get the visa stamp and come back. Those would be my recommendations. It is risky to leave while the extension is pending unless you're very confident that it's going to get approved and that you'll be able to get the stamp to come back.
Question from Dharmil. USCIS says that they adjudicate the cases in the order they received. I see that some October, November, December cases getting approved, but the previous one that were being filed did not get approval. Dharmil, that is the biggest joke that the USCIS is telling, that they go with the order in which they receive it. Really? You're trusting them? You're believing them? No, don't do that. They don't do that often. They never do that. Especially in the adjustment of status, they never ever did it. If you have seen especially the adjudication in the year of 2022, there are a lot of people who filed recently. I mean, they got green cards within 2 to 3 months. There are people who have been pending from October of 2020 still did not get the approval. And what to say about them? I mean, they did not went with the order at all. It's completely, they don't go. It depends on the officer who gets it. It's just a statement they make it to satisfy the Congress requirement that they are supposed to work properly, but we know they're not working. What I would recommend is that if your 485 has been pending for more than 18 months, you can file a writ of mandamus in the federal court. That's an easy way of getting your case adjudicated only if the final action dates are current.
MP Sarda says, what is the criteria for getting the child's age locked under the F2A category? The I-130 is not approved yet. So here, the I-130 has to be approved and the priority date has to be current from that point. Only then can you determine what the child's actual age is or what their CESPA age is. And so when that I-130 gets approved, if the priority date is current at that time, based on possibly the final action date, possibly the filing date, depending on which chart USCIS can be used in that month, then you take the amount of time the I-130 petition was pending, subtract that from the age, and if that puts the child's age under 21, and they then seek to acquire the green card within 1 year of the date becoming current, then they are locked. Now, how do you seek to acquire? Either by filing the 485 or by moving forward with consular processing if you've done the NVC process and logging into the account in that CX system.
Dhruv Pandey has this question. My wife has an approved O1, but they still have filed a H-1B upon the company's recommendation. Her H-1B got picked up. While the H-1B is processed, can she travel to India? Strategically, sometimes it may be advantageous to have a H-1B over O1 because O1 is not a dual intent visa. So I think so strategically they did a good job in filing the H-1B. Now, definitely do not travel while the H-1B change of status is pending. Wait until the H-1B is approved and then go and come back after October of 2023. That would be very advisable for you. Shabir has this question. What's your projections for the May 2023 visa bulletin projections? In the employment-based, we are not expecting any forward movement, at least not significant enough. If there is anything, it will be very, very slight forward movement, if there is any. But if anybody is expecting to cross January of 2015, absolutely not. Definitely not. There may be, if any, just a couple of months movements for EB2 and EB3.
Tarkishwar says, what happens to dependents if the H-1B holder with an approved I-140 dies while working in the U.S.? Is there any way for them to stay in the U.S. and get a green card? So there are some provisions that can be helpful if the 485 has already been filed. There's a special provision, INA 204L, that allows the dependents to continue the green card process even if the main applicant has passed away. The problem is if the 485 has not been filed, because of course nobody's priority date is current, in that situation, only the I-140 petition can be reinstated to allow the dependents to later file for the green card when the date becomes current, but they have to have a way to maintain their non-immigrant status in order to get to that point. So if they're on H-4, they need a way to change status to some other visa that they might qualify for. So the options become very limited in that situation.
Question that is coming up with regards to the priority date is 2014. And does the USCIS issue an RFE if the priority date is not, final action date is not current? For the 485J supplement, yes, they do issue an RFE very frequently, even if the final action date is not current. We have also noticed this issue that they are calling for 485 interviews when the priority date is not current, a significant number of them. So your company may need to be able to give you the 485J supplement if there is an RFE or if there is an interview. If you're thinking that, okay, my priority date is not current, in the next 10 years it's not going to be current, why should I worry about my company giving me a 485J or not? No, you need to worry about it. You need to be prepared. What are the alternatives if your company is not going to give you the 485J supplement?
Shruti says, my AP is expiring 3 months before my travel to India. Will it be an issue when I come back at the port of entry? Can I renew it after I come back to the US? So as long as the AP is valid at the time you're traveling back to the US, there's no issue there, even if it's only expiring a month from the time of your entry. It just has to be valid on the day you're entering, and then you can turn around and file for that renewal as soon as you are back in the US.
Jay has this question. He lost his job, and what if he's going to get the GC getting denied? Well, GC is not going to get denied automatically just because you lost the job. There are different ways. I definitely recommend that you need to contact a lawyer. There are different ways to save you.
Jorge says, does automatic visa revalidation apply to F1 holders while on STEM OPT with the expired visa? Yes, it does. So it's only for trips to Canada or Mexico. F1 also gets some adjacent islands they can travel to, but your trip has to be for less than 30 days. And then you can use the expired visa stamp. Make sure you have your valid OPT card, and you should get an I-20 from your school endorsed for travel as well.
Amit has this question. He found the date of birth certificate has a different date than that of his passport, educational documents, every other document that he has. What's the solution? Should he correct all the documents? Yeah, you may have to do that though. And it's not that tough as you feel though. The first thing is that you can take the birth certificate and go to the consulate and get the passport approved. And then anytime you file the H-1B extension, you explain to them, look, I never realized that my date of birth is not July 3rd. It's actually December 4th. I only realized when I went for the birth certificate, I never realized it. And now I want to change it. So you can try to change all those things. We haven't noticed any problem when people try to do that, though. The process went through smoothly.
Sai says, my current H-1B is valid till October 2024, and my employer filed for an amendment due to organizational changes, and that H-1 is extended through 2025, but my I-94, my spouse's I-94, is only issued for the old H-1B. So I'm assuming the situation was you had your H-1B approval till 2024, employer filed an amendment, you traveled, and when you came back in, they issued the I-94 for the old date instead of the new date, probably based on the visa stamps. That's quite common. So they should have issued it till 2025, assuming that approval notice had the I-94 on it. Before it expires, you need to take action. You can try deferred inspection. There are some airports that allow you to just send an email for these I-94 corrections. Others make you come in person to do that, but you have to fix it before it expires in 2024. The other option is to travel again and come back in to get the I-94 issued again. But most importantly, know that the actual expiration date of your status right now is 2024, not 2025. And if you fail to take action and then you try to file an extension in 2025, USCIS can come back and say that you've been out of status and unlawfully present the whole time. So make sure you fix it before it expires in 2024.
Ranjit Patel is asking the question, have you seen any EAD-AP extension that have been applied well before 6 months from expiry date getting denied? This context is very important for people because especially for the advanced parole, it's taking a longer period of time for people to get an advanced parole. Is it advisable for them, as we know that the USCIS instructions are that you can only apply the extensions of the EAD and advanced parole within 180 days of expiration. So can you file before? We tried that in H4 plus EADs and we have never had any problem. And there were sometimes we got an issue in RFE, we responded to it, we have been successful in that. But when it comes to the advanced parole, we are recommending people go and apply for it. I mean, they're taking 17 months in some of the cases to issue the advanced parole. So if you're going to wait for it until 6 months, that's not a good idea. Go and file for it. As of now, we have not been reported any RFE or any denials. And if you want to play safe, you can do one thing. You can apply for the, you may want to apply safely, especially for the EAD purposes though, because you need to, you can file well in advance and you can file one more set within the 6 months period of time, just in case if the first one gets denied, the second one. But as of now, we have no reports indicating that if the people have filed before 6 months getting denied or issuing an RFP why you have filed before, we have yet to get any reports on it. We have about 30,000 subscribers plus in the YouTube and about a good number of 20,000 in Facebook. So we should be getting some information from them saying that they got RFE or denial, but we haven't yet got it yet.
RV says, does the I-140 retain the priority date forever? What about someone who already had the green card, but then it was abandoned due to staying outside the U.S. for 5 years? So there are some situations where you cannot retain the green card, the priority date, but being outside the U.S. and losing the green card is not one of them. So the regulation states that once you have an approved I-140 and EB1, 2, or 3, you can retain that priority date on any subsequent I-140 petition that you may qualify for. There's no time limit on that. It doesn't say anything about getting the green card and that later losing it. I'm pretty sure I've done that within the last 10, 15 years, retained an old priority date for someone who had a green card and lost it. The times that you cannot retain the priority date are if the I-140 petition is revoked due to fraud or misrepresentation, the labor certification that led to that I-140 approval is revoked, or the Department of State or USCIS invalidates the I-140 or the labor certification, or there's some material error.
I don't know if there is any precedent case for it, but I think so. There is a rumor that Satya Nadella let his green card go. He's given up the green card and applied for the H-1B and came back and then used the old priority date, Emily. Now, that's a rumor. I cannot confirm it because he wants to get his family quicker into the United States. Back in those days, it takes a longer time. Even still, for the green card holder supposed to get it, it takes a longer time. He's given up and got it back. That's a rumor that's there. Smithsha, is there a possibility for second lottery? Yeah, I think so. There is a possibility for the second lottery, even though last year there was no second lottery on the H-1B. We may be expecting some second lottery because we feel that there are a lot of duplicate filings, that these people may not be filing all those H-1Bs after the invitation that was given to them to file it. Anand has this question what are the expectancies of the EB1 prior to date to move forward? I don't know about it. It's very tough to tell. One thing I can tell that if the prior to date doesn't move by September, we may be in a big soup, Emily. The reason I think so is that the amount of EB1s getting approved for Indian nationals has skyrocketed. The amount of EB1s getting in general has skyrocketed. As everybody knows that we have extra 60,000 green cards available this year, which are not going to be available next year. So if the dates don't move, we may be in big trouble in EB1. Could it be that even if I get an Oscar or a Nobel Prize and to get a green card, I might have to wait for 10 years?
Yeah, I mean, I think we kind of forget that pre-COVID, EB1 was backlogged, and there was a priority date, cutoff date for quite some time in EB1. Earlier, it would come and go. It would become current in October, and then it would retrogress and then become current again the next October. But I think it's going to be backlogged. Now, how far back, that's hard to say, but just with the number of filings that we've seen over the years and the fact that it was already backlogged pre-COVID, the only thing that unstuck it was COVID and all that spillover. Arun says, I moved to my new employer on EAD after being laid off on H-1B because I was able to join immediately. The employer used my EAD to run the payroll already. Can I convince my employer to file a transfer and use that for the I-9? And will that automatically convert me to H-1B? No. So since you already started work for the new employer on the EAD, filing a transfer doesn't automatically put you back into H-1B status. The only way to do that would be to travel at this point, because you can't change status from EAD to H-1B. You have to be in a non-immigrant status, and you're no longer in H-1 status.
Question with regards to if I'm an H-4 EAD, and I used to be an H-1B before, can I get the labor and I-140 application approved and move back to H-1B? The answer is yes, you can. You can apply for the labor certification I-140 and H-4 EAD. Also, a lot of people are on the assumption that you can only do an H-1B. That is completely wrong information.
SP says, I applied for the H-4 and EAD, received the receipt notice, and then went to Mexico to get the I-94 extended based on my spouse's H-1B approval notice. Do I need to send the updated I-94 to USCIS, and how can I do that? So prior to the automatic H-4 EAD extension based on the pending EAD where you have an already extended I-94, I would do that because I wanted them to realize that the H-4 had already been extended, and now I want them to hurry up and issue the EAD so this person can get back to work. It never did any good when I did it. They never gave a new I-94. It never helped speed up the H-4 or the EAD. And nowadays, I don't really see much point to it because you've already got the H-4 extended, so you don't need the new H-4 approval notice anymore. And because you got the H-4 extended, assuming this is an EAD renewal situation, you're automatically eligible to keep working based on the pending EAD renewal. So sending in that I-94 really doesn't accomplish anything, and I don't think they do anything with it when we tried in the past.
Arun is asking this question. Do you guys see any problems in the EAD extensions? Not anymore. Not anymore. The reason is that the USCIS, previously we had to get an EAD approval for us to continue. They changed the rule saying that while the extension is pending, you can work for a period of 180 days. We have never seen that. That means crossing, unless people are lazy and they applied late, like very end. That's a different question. But if you apply 180 days in advance, we have never seen them taking longer than 1 year. Now, obviously, recently though, they said it's not 180 days, it's 540 days you can get employed if the EAD extension is still pending. Now, that 540 days require that you must file the EAD extension this year in 2023. We don't know if it's going to continue in 2024, that 540-day rule, but we for sure know that you can work for at least 180 days after the EAD expires if you file a timely extension. We don't know if it's going to continue with the 540 days. That part we don't know, but 180 days rule, we are for sure know that you can work.
Arun says the primary is going to travel into the U.S. using the AP and the spouse using the H-4. So these two different documents will be presented at the port of entry at the same time. Is this recommended? I've had a lot of people have problems with this. The officers don't like doing all that extra work. So they're either going to make you both use the AP or they're going to make you both use the H-1 and H-4 visas. I don't think they'll let you do one or the other. That's been my experience with them.
Mr. Das has this question that compelling circumstances EAD doesn't have a medical condition. Can he still qualify for the compelling circumstances EAD? Mr. Das, that is just one of the criteria. So it's not the sole criteria though. If you have other things like house mortgage, car payment, economic losses, you can still apply for compelling circumstances EAD. We had several occasions where people did not have any medical conditions and still get the compelling circumstances EAD. Not a problem. Question for coming.
Says, we found the H-1B, H-4, and H-4 EAD extensions and premium processing, all of them approved, but the EAD card still hasn't been delivered. Tried calling the helpline and the card has been under printing since September, I'm guessing 2022. I think it's time for a lawsuit. I'm assuming that, you know, the employer or the employer's attorney can contact the premium processing unit by email, but you, as the H-4 holder, aren't able to do that. Your only option is to keep calling customer service. So it may be time to seek a lawsuit in order to get them to figure out that they need to fix that situation.
A question from Akash Kant. Someone I know has a job offer from one company, but he's working for another company. But the company that had a job offer got picked up. Can he transfer? Can he transfer that petition to the company that he's working? The answer is no. If the H-1B is selected with company B, if you're not working for company, let's say you're working for company A, but you got selected in the lottery with company B, you can't transfer that lottery to company A. The only way to do it is that get a H-1B approval with company B, and on October 1st, you can file a change of employer to company A. That's the only solution that you have.
All right, I think we are out of time for today. Thanks everyone for joining us, and thank you all for the anniversary wishes. It's been a good 26 years, and here's to 26 more.
Thank you very much for tuning in.